All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable J.P. Cohen, the judge, presiding. All persons having business before the court draw near to the attention and will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. We've got two cases on the docket. Before we begin, let me introduce the panel. I've been introduced to you. To my right, Judge Richard Orfinger, and then to my left, we have an associate judge from Lake County, Judge Lawrence Cemento. We're happy to have him here with us. If anyone has any electronic devices, noisemakers, anything, if you could just make sure that they're on silent mode so that they don't interrupt any of the arguments in the cases. We have two cases this morning. Both of them are civil cases, and so each side will be entitled to 20 minutes each for their argument. The appellant can reserve time for rebuttal. I have a default setting of 5 minutes, but if you'd like something other than that, just let me. All right. So, okay. So you're going to see it's on 20 now. But you're ready to go. You may proceed.
I'll have 5 minutes for rebuttal.
You will have 5 minutes for rebuttal, but there's no penalty if you don't use it all.
Thank you. Good morning, Your Honors. We are here today on a judgment that was entered by the trial court on a case which involved 3 counts. One was for declaratory judgment action, which was to set aside a merger that took place for the corporation of LALLY Orange Buick. That count was not granted by the court, and the court did not find evidence that the merger had needed to be set aside or anything was done wrong or fraudulently in that case. Second count was a count for breach of fiduciary duty, stating that there had been misappropriation of funds, etc., from my clients, which is LALLY.
I don't think you've appealed that, though.
I didn't. That's what I'm getting to. So today we're here on a very narrow issue, quite frankly, and that is the valuation that was asked for, the statutory appraisal valuation that was done under Chapter 6.
Let me ask this. Let's say that we start the clock. And you warned me too.
That's what happens when you have amateurs.
That's right. Let's say that the trial court had agreed with appellee's expert.
Okay.
And used that figure. Is there anything to appeal?
I would be before the court stating that he did not comply with the valuation techniques that Chapter 607, 1301 state, but
Okay.
I think that she was well within her rights. And I want to say at the outset, I believe the court, and I argued in the closing argument, that if the court chose if there was substantial record evidence to come up with a number that was between the two experts or on her own, she was certainly capable of doing that. Our argument today is that the evidence is not in the record to support
All right,
the
I just want to
1.9.
make sure, because you spent a lot of time in your brief talking about why your expert was so much better than their expert. And that's really a weighing.
I absolutely agree with the court.
Okay, so if we assume then for the sake of discussion that the trial judge could have used appellee's expert or could have used your expert.
Correct.
Now the trial court didn't do that, and so the issue then simply becomes, was there competent substantial evidence for the $1.9 million?
Exactly.
Okay.
But I want to say that I do not believe, and I would probably be arguing before the court had she chosen that expert, which she certainly was capable of doing, that it did not meet the standard of what you have to do in order to value under 607, 1301. I'm not here for that, but I would have.
Your argument, if I understand it, is not the appellee here testified, didn't she, that the 1.9 was the value? Her testimony was
Correct. She made a one-sentence testimony.
Your argument, though, is that although there was some evidence of it, it's not competent and substantial.
That is correct.
Okay. So you don't disagree, though, with the idea that if the trial judge had wanted to take some of what expert A said and some of what expert B said and somehow come up with something and shown us her work, that would be within her discretion.
Absolutely. In fact, I think that the cases, and when the judge questioned me on closing argument as to whether or not she had the ability to do that or whether she had to hire an expert, I believe the law is very clear that states that she could have taken the numbers, let's say that one expert said,
Could have
and
changed
used
the
the formula
multiplier.
for, right, and changed the multiple.
Could have changed the number of years analyzed.
Correct. As long as there's evidence in the record for her to have support for changing those numbers, I think she was well within her jurisdiction to come in and do that and make a finding on her own. And that's what I said in the closing argument, and that's what I would say before this court. I think that's the law.
And the wife's testimony, former wife's testimony, came from apparently some financial documents that had been provided to an unknown, unnamed expert.
Correct. And that I would address. The statute requires, and I think there could be some confusion as to whether or not you have to do a full-blown appraisal when you give the appraisal notice to the minority shareholder. There's no requirement. The statute's very clear that you have to give the last financial statements. It doesn't really tell you more than the last financial statements, the balance sheet if you have them, et cetera. It's not a full-blown look at the company in order for you to give someone their appraisal notice. We believe that we met those requirements and provided the financial documents that were needed, but her...
Do you think that perhaps the former husband's actions, I mean, immediately before the ink on the final judgment of dissolution was dry, he was coming up with ways to get her out of the corporation?
There's no doubt that there was acrimony, and I've been involved in this from the very beginning as well as Mr. Dellinger. I think the difficulty with that is that he knew that he would be facing the most scrutiny you could possibly get from a court.
Isn't that
So he,
something that you know, perhaps should have been dealt with at the time of the final judgment, where you know, of dissolution, where you say you don't keep these people in business together, except your client put 0 as a valuation of the stock during the final
judge
judgment.
put 0. The judge found that it had a value of 0 in the final judgment, and then somehow 4 years later it now has a value, if you were going to look at the 1.9, of $8 million in a 4-year range in the downturn of the economics of the whole situation. But the judge in the trial court at the dissolution, where they said that it had a 0 value, relied on our exact same expert that we used in this trial 4 years later that now says it has, well, that expert did not say that. The 1.9, I'm not sure where it came from, and that's our difficulty today, Your Honor. When you look at the 1.9, you're right. It was based on, and the only testimony that's in the record is a statement from Mrs. SIMI SANDHU that said that she got the financial records, and on that limited information, she put down a 1.9 value that she got from some undisclosed, unknown, I think it was an accountant expert valuator. No evidence was presented to that, no evidence, and it's their burden. The case law is clear that once a judge does determine that there's going to be a statutory appraisal trial, it's each party's burden to prove their respective values.
Let's say that we agree with your position. What relief are you seeking? What do you think that, you know, what should we do? What should the trial judge do?
I believe that I believe it should be remanded back to the trial judge, and I believe that the trial judge has to go with the customary and standard valuation that's required under the statute, and I believe that the only expert that did that in this case that has any experience in car dealership
So
business.
you think that they have to pick yours?
That's what I would argue, yes. But at a minimum, I believe it should be remanded to show where there's any substantial evidence whatsoever instead of hypotheticals, which I will go through with the court because each of the hypotheticals has absolutely no record support.
Couldn't the judge have an independent appraiser?
Absolutely.
Okay, so that's another option.
Yes. And I'm not sure I put that in my request to the court, but I absolutely believe that they could get an independent appraiser in. The statute allows you to do that. So how we look at it, when you look at what was presented into evidence, as you know, and I think you guys have read because of your questions, you know that the 1.9 was stated by one witness based on an appraisal form that everybody said was on limited information. It was argued in the closing arguments that it was on limited information. And we can't tell where the real error lies, is we can't tell from a 1.9 written down on a piece of paper whether or not it followed any of the customary requirements of valuation that's set forth in the statute. And I think it's very telling that in the answer brief, you don't see any record cite or support of that $1.9 million other than 4 hypotheticals. As we know from the Nunes case that came out of this district, a hypothetical is not something that can be used to create substantial evidence. But I'd like to go through those hypotheticals to show how they don't work, even if you try them. The first hypothetical that they use is they say maybe the court went in and looked at Morrison and said he was conservative in the cash flow that he used. And his number was, and this is their expert, Morrison is the police expert. He used $469,000 as his cash flow. Well, we know that there's a finite amount of evidence before this trial in order to get the cash flow. Those are the dealer financial statements and the tax returns. There was no other evidence as to cash flow of the dealership coming from any witness other than the numbers that were on those reports. In their hypothetical, they say, well, maybe the court decided that the cash flow was too conservative and increased it by almost double and said, let's just plug in $764,000 as opposed to what their expert found, $469,000. Well, there's no record support for almost doubling the cash flow number because the number is the number. It comes directly off the financials, and there's no way to increase what both experts used from the financials, which was the tax return and the dealer financials. That's what they do, and basically what they do is say, if we use 764, which is a number that just comes out of the air, it's a made-up number, it's backing in, it's using an exponential X to say if I plug in 764, then maybe that's how the judge got to $1.9 million without any record support.
Well, there was some issue as to whether there were certain loans or whether that was equity capital.
Correct. That would have absolutely no impact, the loans versus the equity, on the cash flow nor the pre-tax earnings. These are just earnings. That may come in down the road, but it has nothing to do with what your and that's the number they changed, the cash flow and the pre-tax earnings under the income approach. So there's no way that the loans or equity would have any bearing on that whatsoever, but I do want to address the loans versus the equity. These same loans that have not been determined one way or the other by the court, although in the hypotheticals you have to assume that the court found that they were equity in the company and not loans, these same loans were the same loans that were before this trial court in the dissolution action where it was found that those loans were in fact loans. And in this trial, the only evidence in there from the accountants, from the dealership itself, is that these loans were in fact always from the inception treated as loans, and even after an audit they were treated as loans by the IRS by allowing us throughout the inception of the dealership to the present day.
The client wasn't always consistent in how he treated them.
There's a difference. So you have the dealer financial statement, which the dealers are concerned, the manufacturers are concerned with the fact that they're going to get paid first. So they don't care if there's a shareholder insider loan because you can't pay that shareholder insider loan before the priority of paying back the dealership. So it doesn't matter to IRS. That's why the audit came through and we were okay with treating them as loans. All they care about is your ratio for the dealership of you being able to keep your floor plan. So as long as they know that the loans that you're referring to are shareholder loans, they don't mind if you treat them as equity on their report because you're not getting paid back. The principals of the dealership are not getting paid back before the actual manufacturer or anybody that you owe your floor plan money to. So that's not a concern. And there was no testimony after the accountant that's been the accountant for this dealership since its inception. There was no rebuttal testimony as to the fact that that's not standard in the industry for you to put on a dealer financial statement that it's equity when it's really shareholder loans, because shareholder loans to the manufacturer don't really matter because they're going to come secondary to what the manufacturer needs. So I don't think there's any evidence in the record that they were not loans other than the dealer financial statement, which was explained, and the unrebutted testimony clearly showed that they've always been loans and that the IRS has audited this issue and has come out with the fact that to this day we are still treating the same exact loans as loans to the IRS.
You were going through the hypotheticals.
Okay, so the next hypothetical, what they do is they go in and say, okay, we've now plugged in the cash flow under the income approach and we've moved that by almost double. Maybe she came up with a cash flow of 764 versus the 469 our expert did. Then the next X factor that they change is they take the pre-tax earnings and they say, well, maybe we look at the pre-tax earnings and where our expert found that it was $1,176,000, we'll just bump that up to $1,786,000. Again, you have finite evidence in this trial. All the financials came from the two statements I just said, the dealer statements, the financial reports, and the tax returns. And there's no other evidence that would ever suggest that you could change that information, that universe of information that was finite in those two documents by almost $700,000. We then get to the cap rate. And the next hypothetical scenario they use is a cap rate, which is what the experts called a build-up number. And basically the cap rate, the higher the cap rate, the lower the value, the lower the cap rate, the higher the value of the dealership. And in this, they change out what their expert found as 13.6 as the cap rate and said, well, maybe that was a little too conservative. We're going to knock it down to 8.3 because, again, it adds up to the $1.9 million, which is what the judge selected as the value. If you look at the cap rate and you go back into the testimony, which I would suggest is in Morrison's report, he states that in order to determine the cap rate, most of his numbers come from outside publications that then you build up, and the only number that has any judgment to it is something called the actual dealer risk. Means for this particular dealer, I have a little bit of judgment as to whether or not there's a greater risk in buying this dealership versus another dealership, but that's the only judgment part. And when you look at that, it goes through various factors that you look at to say what would cause this dealership to be a risk. And if you look at the unrebutted testimony and the testimony from both experts, they both say this was an underperforming, not great dealership, didn't do great on things, and that's both testimonies. That's their expert and our expert. And there was no testimony to say that the risk, for some reason, should be anything other than what Morrison found in his report. So again, there's no evidence in the record for the judge to have relied on changing that rate, and it was only 2% the risk. So even if you change the rate from 2%, you don't get a swing of almost $1 million, which is what we're talking about here. We're talking about $1 million difference between what Morrison's highest number was and what the court actually found, another extra million tagged on. And the final hypothetical they use is the multiples. Car dealership business, the multiples are a big deal because it comes in and uses factors outside and says, what is a multiple that you would pay for this dealership? And they say, let's plug in 4.57 as a multiple, and this is Presidio's high multiple, and there's evidence in the record to that. First time you see evidence in the record. But if you actually go back and look at the record, there is no 4.57 multiple. $4.57 million is the value that you found if you use the Presidio high multiple. There's a lot of time spent in the answer brief saying that that 4.57 was a Presidio multiple. It's not. If you look in the record at the charts that were used, and I think it's the record page 1154, it clearly shows that the 4.5 million was a value. It was not a multiple number. And in fact, the testimony from their expert specifically says that the highest multiple anywhere, he didn't use it, but the highest multiple anywhere from Presidio is 3.75, which again does not get you close to $1.9 million. So when you look at these hypotheticals that aren't even based on any record evidence, and I don't think that they meet the standard of substantial competent evidence, which is required by the court, even if she were to take her own machination, own calculations to come up with something, there's just nothing in the record to support that.
No, you're into your rebuttal time.
Thank you.
May it please the court. My name is Richard Dellinger, and along with Jennifer Dixon and Melody Lynch, we represent the appellee, Ms. SIMI SANDHU. This is a case where the trial court heard 4 days of testimony over 2 months and reviewed over 150 exhibits. 3 volumes in your record.
Show us where there's competent substantial evidence in the record from those 4 days of testimony over X months.
Yes, Your Honor.
To support 1.9 million.
First of all, Mrs. SANDHU's direct testimony. In her direct testimony on pages 36 through 38, she testified to $1.9 million as her valuation number.
That's competent substantial evidence for someone, she's not been involved particularly in the business. There's no basis for that belief. It's like picking a number out of thin air. You think that constitutes competent substantial evidence?
Her testimony was that she consulted a valuation expert. The valuation expert reviewed the financials.
Would that be hearsay?
It would be hearsay if it were objected to. And if it were objected to, we would have brought in that valuation expert and had that person testify. But it was not.
Was that person listed on a witness list?
I do not recall, Your Honor. I do not recall.
Was that person subpoenaed?
I do not recall, Your Honor.
All right, so that's kind of a hypothetical then, isn't it?
The witness testified to a valuation based on a valuation expert, and not only was it part of the direct examination, but it came out in cross-examination. It was elicited on page 98 of the record during cross-examination, that same number.
Didn't counsel, for the former wife at the hearing acknowledge that, well, that's really a high figure?
Counsel for the former wife at the hearing was myself, and we introduced the testimony.
I wasn't going to use your name, but I'm going to do that. Didn't you acknowledge that was a high number?
We acknowledged that that was a high number. Yes, Your Honor, we did. But it was within range. And Moon v. Moon and Morales v. Rosenberg both say that if there is testimony within range, testimony evaluation that is within range, then it is not an abuse of discretion.
Have some basis. I mean, it can't be. I mean, this isn't. A car that you're valuing. This is a stock of a closely held corporation, and there's a lot of factors that go into the valuing of stock of a closely held corporation.
And it did have basis. It had basis in the test.
I consulted with Madam Cleo. That has a basis.
This is substantially different than a consultation with the psychic, Your Honor.
How do we know? We
Because
don't know anything about the person who she alleged. We don't even know whether she did. Just she said she did, but we don't have any backup in terms of documentation of that. We don't have any testimony from this other witness, so we have no idea what the background of that figure, where it comes from, what the basis of it, how was it computed, nor did the trial judge have that information.
Respectfully, Your Honor, it's not for this court to re-weigh the testimony. The trial judge listened to the witnesses, analyzed the testimony, reviewed the exhibits. Exhibit 117 included this valuation number. The trial judge heard from 2 valuation experts, and the trial judge determined what she believed to be competent and substantial evidence to support the fair valuation.
You get to look at the record and decide whether there's competent, substantial evidence.
That is the test, Your Honor.
That's what we're doing.
Did the trial judge, either at the hearing or in her judgment, give any indication as to how she arrived at that number?
In her judgment, the trial judge referred at paragraph 9 and 11 to Mr. Morrison's testimony and Mr. Rosenfield's testimony, our expert and their expert. And the trial judge said that Mr. Morrison was credible and that Mr. Rosenfield was not. And as we showed you in the briefs, the judge adopted a $1.9 million number based on the testimony of the former wife on cross and direct. And then the judge can look at Morrison's work papers and back up that number based on the evidence in front of it. There was evidence in the record that the former husband in this case received $500,000 from this company, more than what he valued the company at, in order to pay his equitable distribution payment. There was evidence in the record.
Let me ask you this. Morrison's testimony was the one that the trial court credited. What was his highest number? Round numbers.
800, maybe 900, 800 to 900.
So we end up with something that's, basically almost 100% or so higher. I'm trying to understand. I mean, I understand. So we've got the 2 experts. The best testimony there is 800,000 or 900,000, and we have the appellee who testifies as to 1.9. But again, the concern I have is that if this was something that the average layperson could value. I mean, I could tell you more or less what it costs to buy a 6-pack of Coke at Publix. I couldn't tell you how to value a small business such as this. So I think when we look at whether the evidence is competent and substantial, don't we have to look, when it's something that isn't something a layperson can do, don't we have to look at where that number came from? What is it based on to understand? Not that the evidence exists. I mean, clearly it exists. She said 1.9. But whether it's competent and substantial. In other words, does it have legs? And I'm trying to understand, where does this number get any legs other than her testimony?
And the appellee's testimony was based on expert review of the financials that were provided to her that were supposed to be accurate. According to the law, when there is a merger like this that takes place, and you're the controlling shareholder, you're supposed to provide completely accurate financial information. The appellee in this case testified that she took that supposedly accurate financial information and took that to a valuation expert to come up with her valuation, which is what is required by the statute. She took that to an expert.
Why wouldn't you have called that expert if you believed you could present value at $1.9 million? You know, with all due respect, you presented an expert whose highest figure was $800,000 to $900,000, and now what you want us is to take that leap of faith but you know what? We had this other expert in the wings that would have testified that it was worth 1.9, and but since we got this testimony in because our client speculated, well, I talked to somebody and they said it was 1.9, that we didn't need to call that that witness. You know, that's a hard pill to swallow.
Your Honor, it is not for this court to reweigh the evidence that the trial court weighed.
To show me competent, substantial evidence, and you're making an argument here that we had this witness in the wings and could have called this witness to testify, and I'm telling you that I find that hard to believe, because if I have an expert witness that's going to testify to 1.9, and I have a second expert witness that's going to testify between $800,000 and $900,000, and you choose to call the one that's going to give the lower number, you know, that just doesn't pass the sniff test.
We chose to put the expert up that we were most comfortable with based on the financials that have been provided to us at trial.
Okay.
And recall, Your Honor, we argued that the financials that were provided to us at the time of the merger that were supposed to be accurate turned out to be inaccurate and misleading. So we put the expert on at trial that we were most comfortable with. It is not our fault that the financials that they were supposed to provide turned out to be inaccurate and misleading. It should not be, Ms. SANDHU should not be penalized for relying on evidence that was provided to her in accordance.
Who has the burden of establishing, once they do the notice, who has the burden of establishing the value of the business?
Once they do the notice, they have to put a value in the business, and then we have to respond with our value. And that's what happened. They provided a notice, they provided us a value that they believe was low.
At this trial, who had the burden?
At this trial, we both had countervailing petitions for evaluation, so we both had the burden. There was a judicial valuation count in our complaint, and there was a judicial valuation count in the counterclaim. So we both ultimately had the burden to establish what was fair value. And recall, Your Honor, in closing argument, the court asked, should I appoint an independent valuator to look at this? Should I bring someone else in to come up with a number? And the response was, no. You can value this based on the evidence in front of you. You don't have to select one expert or the other. You can value it based on the evidence that's in front of you. And, Your Honor, we showed you that the court's opinion of value can be fully reconciled by the valuation report of Mr. Morrison. It's in Exhibit 2 to the trial. It's in Schedule B, and we showed you 3 different ways that opinion evaluation can be reconciled. Counsel invited the court. Counsel invited the court.
And how would you have known if which of those the judge used? I'm trying to figure that out.
It's Judge Blackwell.
I know who the judge was, but I'm trying to figure out, how is it that you know the judge used any one of those methods?
We don't know from the final judgment, and Your Honor, the judge is not required to include findings, to include details on her opinion of value.
So you would acknowledge that of these, that you put forth 3 hypotheticals, but you have no idea that the judge used any of those?
I know what the evidence is in front of the court. I believe,
my question is,
I acknowledge.
Okay.
I acknowledge that, Your Honor, but I don't think it's for this court to go back and reweigh the evidence and reanalyze the witnesses if there is any reasonable inference based on the evidence that's in front of the trial court, that any reasonable evidence is enough to survive an abuse of discretion review. This case is different from Nunez v. Nunez. Nunez v. Nunez, which was authored by Justice Orfinger, was a case where there was a letter of intent that was old from a company that no longer existed. A letter of intent that was old from a company that no longer existed. There was no opinion of value. There was no testimony of value. There were no experts from the party that adopted, that the value was adopted. And there was no invitation to the court to adopt whatever value the court wanted. In this case, the invitation to the trial court was adopt whatever opinion of value you want. You don't have to adopt one of the experts, and you can do it based on the experts or what you feel.
What you feel. So, you know, where's that in the record, that you can do it based upon what you feel? You could pick any number you want.
The invitation is transcript page 1085, line 7 through 1086, line 7. That's part of the closing argument.
Read it.
Make your own independent appraisal and look in the evidence and what you feel. You are not relegated to pick one appraisal or the other.
Look at the evidence. So, you know, you still always have to look at the evidence. You know, you certainly would never make an argument that the judge can do, you know, whatever you feel.
I am not making that argument, Your Honor. In this case, you have to look at the evidence, and the evidence is there. There is competent and substantial evidence. Competent, is it admissible? Yes. It was all admitted into evidence. Is it substantial? Testimony of value on direct, testimony of value solicited on cross, testimony of value by Mr. Morrison, testimony about excess earnings received that really can't be explained based on those opinions of value.
Wasn't the only value testified to at 1.9 million was the plaintiff? Is there any other record evidence showing that value?
The $1.9 million is based on the plaintiff's testimony. The answer is no. The $1.9 million is based on the plaintiff's testimony on direct, and then the solicitation of that same valuation on cross. And as we showed you in our briefs, that opinion of value, $1.9 million, can be fully reconciled using Mr. Morrison's methodology, which is Exhibit 2 in the record, Schedule B. And if you consider evidence of extra earnings coming out of the company, you consider the debates among the experts.
And if the trial judge showed a little bit of her work, perhaps, you know, maybe we could, maybe we couldn't. You know, I don't know. But what if your client got on the stand and testified it was worth, I consulted with my expert in valuations, worth $1.9 billion?
In that circumstance, Your Honor, I don't think it would be supported.
Because there would have to be competent, substantial evidence to support that figure.
And there's number one, there would be an objection on direct examination. Number two.
Let's say there wasn't.
Okay, then it wouldn't even back up to Mr. Morrison's methodology. And we reconciled it 3 different ways in our briefs, based on a change in the multiple, based on a change in the excess earnings, the earnings that was available to the former husband, which he used to pay his equitable distribution payment, based on the extra earnings that were available to the parties. There were multiple ways that we...
Why shouldn't we, at the very least, remand it back to the trial judge to explain to us how she came to the figure that she came to determine whether there's competent, substantial evidence to support that figure?
Your Honor, respectfully, I submit that that's the only thing that you could do based on if you were to agree with the appeal. That's the only thing that could happen. But I don't think it is required by the law. Unlike the dependency statute, where the court requires substantial findings of fact and conclusions of law by statute. This statute requires no such findings.
Well, and had the trial judge accepted one of the expert's values or the other expert value, I think that you would be right. But if the trial judge is going to do something other than that, and there isn't competent, substantial evidence, documentation, testimony of some sort to support that third figure, then that just gives me cause for concern.
Let's assume the trial judge set the value at $10. Wouldn't you be arguing that there's nothing in the record to support that valuation, despite what you say the statute doesn't require written findings? Wouldn't you still argue there's no competent substantial evidence to support that value?
Good question, Your Honor. I think it's a similar analysis as the $10 billion number. If it were very low or very high, it could not be justified using Mr. Morrison's methodology that is in the record as Exhibit 2, Schedule B. And number two, a significant difference would be if there was no invitation for the court to kind of come up with its own number based on the evidence in front of it, then it would be hard to justify the court doing that. But in this case, the court's opinion of value can be justified. There is both competent and substantial evidence, both in the direct examination, cross-examination, in Mr. Morrison's report, which reconciles the number, and then there's an invitation to the court to select its own opinion of value based on the evidence in front of it, and that's what the court did. That's what the court did. Your Honors, the trial court based its valuation on both admissible evidence, which is competent under the Nunez standard, and evidence that was substantial, more than a mere scintilla. You have an opinion of value both from direct examination and cross-examination, an opinion of value that can be justified using Mr. Morrison's report. There was no abuse of discretion by the trial court here necessitating a reversal. The appellants cannot demonstrate any misinterpretation of the statute justifying de novo review. Ultimately, the statute was applied appropriately. The standard of value was applied, it was adopted, that was part of the final ruling. The primary error on which the appellants complained was invited when they asked the trial court to reach its own valuation based on the evidence. As the record showed, the trial court did just that. Accordingly, the final judgment should be affirmed. Thank you, Your Honor.
I would like to point out to the court that during the closing argument regarding this invited error comment, I'd like to read exactly what was told to the court and the question from the court, because I think it was a little confusing. This is from the trial judge. So I guess the question is, are the two parties agreeing that the court can accept the value of one or the other appraisers under the statute based on what was testified to in court in satisfaction of the requirement of 607-1330? Or are you saying that if I agree that we should proceed under 607-1330, but then I need to go through a separate appraisal process? Mr. Dellinger, I think both pled countervailing judicial appraisals with anticipation that you would make a decision based on the experts that we put in front of you. And I would love to hear that stipulation from opposing counsel as well. Ms. Eden, Your Honor, the way I read the statute and the case law that's gone with it is that you have the ability. You don't have to pick one of the appraisals or the other. You can make your own independent in looking at the evidence as to what you feel. You are not relegated to pick one appraisal or the other, or the court can determine that they need an expert, a third person to come in, and that's why when you had asked me, I said, yes, we did offer that to the court, but always the contention has been that if you're going to come up with your own calculation, which she's certainly well within her right to do, and I don't think that's an invited error, the fact that you would come up with a number that is not supported by competent substantial evidence is the issue that we have on this appeal. I would also point to the fact that I think I just heard argument that the financial documentation that was provided at the beginning, before the appraisal notice was filed by Ms. Sandhu, the one piece of paper that has the 1.9, was insufficient. All of those allegations as to whether or not proper financial documentation was provided to Ms. Sandhu were all covered in the declaratory judgment action and the breach of fiduciary duty action, which the court specifically found there was not evidence that we had done anything wrong with the financials. And if you look at the financial documentation that was provided, nothing changed from the financials that were provided to Ms. Sandhu, other than there were additional backup documents to what was initially provided to her in the appraisal notice, which is what was mandated by the statute. It's not volumes and volumes of evidence that you have to provide and valuations that you have to provide. It's the financial documents from the companies, and those didn't change. There were additional documents added, but the idea that we've just heard that there was some inequitable action by my clients in having someone take a loan for their equitable distribution payment. That was all addressed by the court, and it was covered by the court in the breach of fiduciary duty actions, which there was no evidence of a breach of fiduciary duty, and they were covered in the declaratory judgment action, where the court found that the merger could go forward and was proper, and we did what we were supposed to do under the merger document. So with those in mind, we believe that the court did not base, she had the ability to, but did not base her finding on competent substantial evidence, because other than the one line that was written on an appraisal form stating it was based on limited information is not the same standard as the court just asked counsel up here. It's not the same standard as when you have the burden of proof. You're giving an estimate. Even the statute says you estimate what you believe the value is going to be, both for the corporation who's asking to buy the shares and for the appraisal form that's filed by the minority shareholder. It says your estimate of value. When you get to trial, it's a completely different standard, and I think the court recognizes that we both bore the burden of proving with substantial competent evidence what that value would be. And we do not believe that the court or any evidence in the record, forget the wrongdoings because she didn't find any wrongdoings, but any evidence in the record would support an increase of almost $1 million from the highest number that was determined by their expert to add $1 million on that with no support in the record. So we would ask that it be remanded and reversed. Thank you very much.
Thank you.
You both.